Attorneys for the Justice Department will be busy today with hearings on several controversial issues. In one of the most contentious cases, U.S. District Court Judge James Boasberg is expected to determine if the Trump administration violated his orders not to deport Venezuelans under the Alien Enemies Act. The president has called for Boasberg to be impeached and has referred to him as a, quote, activist judge. CBS News legal reporter Katrina Kaufman joins me here in Studio 55. Hello.
Hello, good morning.
All right, so if this judge determines that the DOJ violated his orders, what are the consequences?
Vlad, so there's the potential for the judge to hold someone or the Justice Department in contempt. That could be civil contempt or criminal contempt. And this hearing today to show cause is a final step in that process. It's for the government to tell the judge why they did not violate his orders. But civil contempt could involve fines, it could involve possible imprisonment, or if the judge determines that there's a different remedy he wants to choose there.
What's up, everyone? Welcome, Adam is here, so this has just happened, guys. A federal judge warned actual cabinet secretaries, not low-level staffers, that they're facing criminal contempt charges and potential jail time live on camera for deliberately defying a direct court order. Not corruption, not bribery, just flat-out refusing to do what a court told them to do. The man behind this seismic legal event is Judge James Boasberg.
For criminal contempt, there would be an additional proceeding, and normally that's referred to the Justice Department itself. But if they didn't want to comply with that, if he decides to move forward, the judge does have the option of hiring private attorneys or appointing them as special prosecutors. So those are some of the options. But of course, first, the judge is going to make a determination about whether he thinks they did, in fact, violate his order knowingly.
So when we say that there could be consequences, there could be accountability, who are we signaling out? Like, I mean, the DOJ, is it the person who actually gave the order? Is it Stephen Miller? Is it Steve Bannon? Like who? Who's going to, I'm trying to understand this.
Vlad, I think that this is the big question that's really up to the judge. He could say the lawyers, he could determine it was someone within the Justice Department, potentially someone with DHS, but, we're really speculating at this point who he would think was responsible here.
Wow, fascinating. All right, there's also another hearing that's going to be held in the case of that Tufts University student who was basically abducted from the streets of Boston. What are we hearing about that?
So there's a hearing today in her case, and this is very similar to the Mahmoud Khalil case, the pro-Palestinian activist from
a name that has suddenly become the epicenter of a political earthquake and the target of a furious, relentless assault by Donald Trump himself. Trump has called him a lunatic. Trump has demanded his impeachment. Trump has tried to paint him as a rogue operator, an activist in robes, a deep state saboteur bent on destroying the presidency from within. And now, with the whole nation serving as the jury, Boasberg has fired back not with a press release or a leak to a friendly reporter, but with the most powerful weapon in his judicial arsenal.
Columbia, where the first question has become, is this case taking place in the right court? Because her lawyers are asking for her release. It's called a habeas petition. But what the government is saying is because she's currently detained in Louisiana, which is where they're sending a number of these students that they've arrested, that is the proper venue for this case. Louisiana is also within the Fifth Circuit. That's a very conservative court circuit. So this is likely why the government wants the case to take place there. What her attorneys say is it should either be in Massachusetts, where she was arrested, or in Vermont. And what's very similar here is that, like Mahmoud Khalil, she was moved multiple times after she was arrested. She was taken in Massachusetts, put in multiple detention centers in Vermont. But what her lawyers say is, one, they had no way of knowing where she was. They were not getting any information. So Massachusetts should be the right venue. She was with Massachusetts ICE officers for a lot of this time. But if not, it should be in Vermont. So that's really the first threshold here before other decisions can be made in this case.
Wow, fascinating. That's happening today, right?
He has announced that the Trump administration has until a specific non-negotiable deadline to fall in line and comply with his court order, or the full crushing machinery of criminal contempt proceedings will descend upon them without a moment's hesitation. The reason for this extraordinary judicial standoff is as simple as it is terrifying. The administration allegedly got word of a court order demanding they halt a specific set of deportation flights to El Salvador. They looked at that order. They consulted their lawyers. And then, according to the judge and the evidence laid before him, they made a conscious decision to ignore it entirely. They deported over 200 people anyway. They sent the planes roaring down the runway while the ink was still drying on the judge's injunction. That isn't a legal gray area. That's not a jurisdictional dispute. That is the executive branch looking the judicial branch in the eye and saying, "You have no power here." Can your mind even process the gravity of this? We have crossed into a space where cabinet-level officials, the Secretary of Homeland Security, the architects of immigration enforcement, the very people entrusted with upholding the law, are staring down the barrel of criminal charges because they chose loyalty to a president over obedience to a court. When is the last time that actually happened? Not threatened in a vague, hypothetical law review article. Actually happening. The kind of confrontation that makes constitutional scholars bolt upright in bed at 3 in the morning, drenched in cold sweat, because it signals that the foundational load-bearing walls of the American system are beginning to crack. The executive branch exists in part to enforce the law and execute the orders of the courts. That's the social contract. That's the deal. But in this moment, the administration looked at the order blocking those flights and effectively shrugged. They deployed over 200 souls to El Salvador in direct, flagrant violation of a federal judge's command. Judge Boasberg issued his order, and the administration's response was a dismissive wave and the roar of jet engines. The defiance was not accidental. It was not a miscommunication between overworked attorneys. It was a declaration of independence from judicial oversight. And just when you think this story can't spiral any deeper into uncharted territory, the administration's legal defense emerges from the fog. They are hanging their entire argument on a dusty ancient relic of American jurisprudence, the Alien Enemies Act. This isn't a modern statute crafted for the complexities of 21st century immigration. This is a law etched into the books in 1798, over 2 centuries ago, designed for a world of wooden ships, musket fire, and formal declarations of war against uniformed foreign powers. The administration is arguing that this prehistoric statute grants the president a reservoir of power so vast and so untouchable that it can't be plugged by any court. They are branding the deportees as terror and criminal migrants, framing the entire operation as a national security imperative where the president's word is the final law, and any judge who disagrees is simply out of his depth. According to this philosophy, wartime powers have been activated, a silent invasion is underway, and the courts need to step aside and let the strongman handle it. But reality has a way of intruding on even the most carefully constructed legal fantasies, and reality arrived in the form of a devastating CBS News investigation. While the White House was painting a picture of hardened cartel assassins and sleeper cell terrorists being herded onto those planes, journalists were doing the tedious, unglamorous work of actually checking who these people were. And what did they find? A truth that detonates the entire moral justification for the administration's defiance. A staggering 75% of the individuals swept up in those deportation flights had no criminal record. Not a speeding ticket in the United States. Not a minor infraction abroad. Nothing. 3 out of every 4 people the government labeled as terror threats and criminal invaders have no criminal history whatsoever. The numbers expose the rhetoric as a house of cards. Either the Trump team is engaged in a systematic campaign of misrepresentation, knowingly branding innocent people as monsters to justify an authoritarian power grab, or they have stretched the definition of threat so wide that it covers literally anyone they wish to remove from the country. Judge Boasberg, clearly having reviewed the data and seen the gap between the propaganda and the proof, is not playing the administration's game. He has found probable cause. Probable cause that the highest levels of the government are in criminal contempt. Probable cause that the violation was not a slip-up, but a strategy. He has given them a deadline. By that fateful moment, they must demonstrate compliance, or the sanctions and criminal contempt proceedings will commence without delay. Think about what that visual would look like. The Secretary of Homeland Security, perhaps the Attorney General, top architects of domestic policy, being led into a courtroom not as powerful arbiters of justice, but as criminal defendants facing fines and a prison cell. these officials are now trapped in the most excruciating dilemma imaginable. Do they bow to the judge and follow the court order, thereby admitting the limits of executive power and risking a furious career-ending backlash from Trump and his base? Or do they stick with the president, burn the bridges to the judiciary, and roll the dice on their own personal freedom? This is about more than just immigration. This is the ultimate stress test of whether the judicial branch has any actual power to check a president who has decided he no longer needs to listen. Trump has spent his entire second term pushing this envelope, probing for weaknesses in the system, testing how far he can stretch the elastic band of executive authority before it snaps. He has treated courts not as a co-equal branch, but as an annoying bureaucratic hurdle to be bypassed. And now, Judge Boasberg has drawn a red line in the concrete. He is saying, "You cross the line and there will be a price." But the haunting question lingers. Will the price actually be paid? What happens if Trump simply tells his cabinet to keep ignoring the order? What if he preemptively pardons anyone charged with contempt before the trial even starts? What if the Republican-controlled apparatus of power rallies around the administration and buries Boasberg in a tundra of political attacks, dismissing him as a rogue activist judge attempting a coup against the elected president? We could be spiraling toward a future where the judiciary issues its orders and the executive branch, backed by a partisan militia, simply responds with a shrug. The White House has already announced its intent to appeal, a process that will weave through the circuit courts for months. But in the interim, do the flights halt or continue? If they keep deporting people while the ink dries on the appeal, does Boasberg follow through with the threat and start hauling people off to the lockup? Every single path forward from this juncture leads deeper into the constitutional jungle. Let's peel back the layers of this onion because both sides are constructing arguments that sound superficially reasonable until you dismantle the core components. What actually triggered the judge's fury? The administration has been running what it euphemistically calls enhanced deportation operations. These are mass removal flights targeting mostly Central American migrants, sending them back to places like El Salvador. Civil liberties groups and immigration advocates rushed to the courts with lawsuits arguing that due process had been completely vaporized, that individuals with legitimate asylum claims or even established legal status were being swept up in these dragnets and catapulted out of the country before a lawyer could pick up a phone. Judge Boasberg looked at the evidence and issued a temporary restraining order. A TRO is standard Judicial 101. When there's a serious allegation that the government is actively, irreparably violating people's rights, a judge hits the pause button to keep things frozen while the legal arguments play out. It preserves the court's ability to actually fix the problem later. You can't undeport someone easily, but the Trump administration, armed with a radical new legal theory, decided that the standard rules of civil procedure didn't apply to them. Their position is that the court order was void from the start because they were operating under the mystical, all-encompassing umbrella of the Alien Enemies Act. They claim this act grants the president a divine right of removal that no mere federal judge can touch. The Alien Enemies Act is a fascinatingly terrifying piece of parchment. It was passed in 1798 during the quasi-war with France, an era of intense paranoia about foreign infiltrators. It permits the president, during a formally declared war or an invasion by a foreign nation, to detain and deport nationals of that enemy country without the exhaustive legal procedures normally required. Historically, it's been used sparingly, most infamously as part of the legal patchwork that justified the internment of Japanese Americans during World War II. That's the precedent they are reaching for. It is a law stained with the blood of civil liberties past, and the administration is dusting it off and claiming it applies to a conflict with transnational drug cartels. Their argument is a rhetorical masterpiece of stretching. They claim that the border situation constitutes an invasion and that the cartels constitute a foreign enemy nation, allowing the president to act with what they believe is virtually unlimited authority. The legal community, across the ideological spectrum, has largely viewed this argument with a mixture of horror and disbelief. Congress hasn't declared war on El Salvador. We have diplomatic relations with El Salvador. We send them aid. They are not a hostile enemy power. Calling a Salvadoran mechanic who crossed the border illegally an enemy alien under a 1798 statute is a distortion of language so severe that it borders on Orwellian. Then the CBS investigation landed like a bunker buster on the administration's factual claims. The White House needed those deportees to be scary. They needed them to be terrorists and killers because that's the only way to justify invoking a wartime statute. But when the receipts were checked, 75% of them were just people, regular, non-criminal people. This factual collapse matters immensely in the courtroom. Judge Boasberg isn't just deciding abstract law, he's looking at the government's conduct. If you claim an emergency so severe that you must blow up the separation of powers, but the evidence shows you were mostly deporting non-criminals, then the emergency looks manufactured. It looks like a pretext to seize power, not a response to a genuine threat. The finding of willfulness by the judge is the atomic bomb in this legal standoff. For criminal contempt, the standard is high. You must prove beyond a reasonable doubt that the party knew about the order and intentionally blew it off. The fact that Boasberg has signaled probable cause on this tells us the evidence of deliberate defiance is overwhelming. The lawyers were notified, the order was crystal clear, and then the government consciously decided, we're doing it anyway. Now we arrive at the specter haunting the Capitol, the mechanism of the prosecution. Normally, the Department of Justice prosecutes contempt citations, but the DOJ works for the president. The idea that Trump's attorney general is going to aggressively prosecute the Secretary of Homeland Security for following Trump's orders is a fantasy. This creates a black hole in the legal universe. Boasberg may have to reach into the dusty toolbox of judicial authority to appoint an independent special prosecutor, a move that would trigger a massive separation of powers brawl. The Justice Department would likely refuse to cooperate, refuse to fund it, and refuse to enforce any eventual warrants. This is the nightmare gridlock the framers feared. The physical mechanism for compelling compliance is broken. The only thing backing the court's order is the tradition of obedience, and that tradition is being shattered in real time. The April 23rd deadline is the inflection point. The cabinet is in a state of panic because they know the judge is serious, but they also know the president is volatile. If they comply with the order and cancel flights, Trump could fire them by tweet within the hour for weakness on the border. If they defy the order and get charged with contempt, they face personal legal bills, mugshots, and the real threat of confinement. They are trapped between a cell and a tweet. The political ecosystem is feeding on this chaos. For the MAGA base, this is validation of their decades-long complaint that unelected judges are running the country. They see Boasberg, an Obama appointee, as exactly the kind of deep state operative they want purged. Trump is using this to fundraise, to energize the base, telling them the establishment is so scared of him that they're throwing his own people in jail to stop him. The midterms are looming, and Trump is betting that a majority of voters in the districts that matter will see his defiance as strength, not lawlessness. For Democrats, this is the proof of authoritarianism they have been warning about since the escalator ride. They are framing this as the moment the mask fully dropped. They are running clips of the judge's stern warnings juxtaposed with administration officials fumbling to justify the deportations. They want this to be the defining issue of the election cycle. Democracy versus dictatorship, courts versus kings, the law versus the man. The deeper dive into the Alien Enemies Act reveals the terrifying precedent being set. If the administration wins this argument, the act becomes a plastic, stretchable tool for any future president. Declare a migrant caravan an invasion. Declare the Chinese government a predatory incursion. Declare drug traffickers enemy nations. The statute would swallow the entirety of immigration law. Due process would vanish. The president could point to a group, call them enemies, and put them on planes. Judicial review would be a dead letter. The slippery slope leads to a cliff. Every single future abuse of power will trace its lineage back to this moment, back to the argument that the 1798 text gives the executive a blank check. The human cost of this procedural battle is being paid by the over 200 individuals already jettisoned to El Salvador. They are gone. Whatever legal claims they had, whatever families they left behind, whatever legitimate fears of persecution they possessed, all of it was moot as soon as the landing gear retracted. They were deported in defiance of a court order, and no one can easily bring them back. This is the reality that gets lost in the legal jargon. Lives are being erased by a process that is arguably illegal. Even if you want strict immigration enforcement, the method of achieving it matters because the method either restrains or empowers the state. As we stare down the barrel of the appeal, the war is far from over. The Circuit Court will weigh in, but the Supreme Court is the ultimate prize. The conservative majority will face a defining test. They are ideologically aligned with executive power, but they are also institutionalists. Are they willing to nullify the contempt power of the district courts? Are they willing to say that a president can simply ignore a TRO? The implications for the judiciary's power are existential. If the Supreme Court sides with Trump, the district courts become optional. If they side with Boasberg, they risk a confrontation where the administration might just ignore them too, revealing the ultimate frailty of the judicial branch's enforcement power. The final guardrail is the U.S. Marshals. If a contempt order comes down and the Marshals are ordered to arrest a cabinet secretary, and the president orders the Secret Service to block the door, we are in a full-blown constitutional crisis. The cabinet officials are panicking because they know the history books are being written right now. They didn't sign up to go to prison in order to deport a Salvadoran baker who missed a court date. They are looking at exit strategies, consulting personal legal counsel separate from the DOJ, and weighing the costs of loyalty. Some of them might break. Some might resign rather than face the gavel. This is the atmosphere inside the executive branch right now. A frenzy of panic calls to lawyers, of internal memos analyzing liability, of staffers updating their resumes. The judge has successfully weaponized personal anxiety. He knows he can't arrest the president, but he can absolutely make life miserable for the people who do the president's bidding. That's the crack in the armor. The administration is a monolith of bravado on TV, but inside it's a collection of individuals who don't want to be martyrs. The April 23rd deadline is a ticking clock, and when the buzzer sounds, we will find out if America still has a government of laws or a government of men.